In a courtroom in Broward County, Florida, a judge looks at a sheet of paper. The paper contains a risk score. The score has been generated by a computer program, a proprietary algorithm developed by a private company that has analyzed a set of factors about the defendant standing before the court and produced a number between 1 and 10. The number is supposed to represent the probability that this person will commit another crime if released. The defendant does not know how the score was calculated. His lawyer does not know how the score was calculated. The judge does not know how the score was calculated. The company that made the algorithm has declined to explain how it works, citing trade secrets. The score is 7 out of 10. High risk. The judge considers this information alongside everything else in the case and makes a decision about this person's freedom. Somewhere in a server room, the algorithm moves on to the next case. The American criminal justice system produces racially disproportionate outcomes. This is not a contested claim. It is documented in arrest statistics, prosecution rates, conviction rates, and sentencing data going back decades. Black Americans are incarcerated at 5 times the rate of white Americans. They receive longer sentences for comparable offenses. They are more likely to be denied bail. They are less likely to receive parole. In the early years of the 21st century, a technology company offered the American criminal justice system a solution to these disparities. The solution was an algorithm, an objective, data-driven, mathematically rigorous tool that would remove the subjective judgment of individual human beings from decisions about bail and sentencing and parole, and replace it with a consistent, evidence-based risk assessment that would treat every defendant the same way. The algorithm made the disparities worse, and it did so in a way that was, by design, impossible to challenge. The use of actuarial risk assessment in criminal justice is not new. For most of the 20th century, parole boards and sentencing judges had access to various forms of risk assessment, structured evaluations of factors associated with recidivism, designed to provide some empirical basis for decisions that would otherwise rest entirely on individual judgment. The argument for algorithmic risk assessment was, on its surface, compelling. If you could identify, through large-scale analysis of criminal justice data, the factors that actually predicted recidivism, and if you could weight those factors consistently across every case, you would produce decisions that were more consistent, more predictable, and potentially more fair than decisions made by individual human beings. The bias in human judgment would be replaced by the neutrality of mathematics. Northpoint developed COMPAS in the 1990s and began selling it to criminal justice agencies in the early 2000s. By the mid-2010s, it was being used in jurisdictions across the United States. Hundreds of thousands of defendants had their risk scores calculated. Those scores were placed in front of judges as part of the official case materials. What the company did not publish, what it declined, consistently and on trade secret grounds, to make available for independent examination, was the methodology, the specific factors the algorithm considered, the weights assigned to those factors, the mathematical process by which a set of inputs was converted into a risk score. All of it was proprietary. All of it was protected. And because it was protected, no defendant, no defense attorney, no independent researcher, and no judge could examine the process by which the score that might determine their freedom had been produced. In 2016, 2 investigative journalists at ProPublica, Julia Angwin and Jeff Larson, decided to look at what the algorithm was actually doing. They filed public records requests in Broward County, Florida, and obtained the COMPAS risk scores for approximately 7,000 defendants, along with their criminal histories and the subsequent 2-year record of whether they had actually been rearrested. They then did something straightforward. They looked at the numbers. The pattern that emerged was not subtle. Black defendants were significantly more likely to be rated high risk than white defendants with comparable criminal histories. White defendants who reoffended were more likely to have been rated low risk. Black defendants who did not reoffend were more likely to have been rated high risk. The ProPublica analysis produced 2 specific findings that became the most cited numbers in the subsequent debate. Black defendants who did not reoffend were nearly twice as likely as white defendants who did not reoffend to be rated as higher risk, and white defendants who did reoffend were more likely to have been rated lower risk than black defendants who did not. ProPublica illustrated their findings with specific cases. A black woman named Brescia Borden, 18 years old, had been arrested for riding a bike that turned out to be stolen. Her COMPAS score was 8 out of 10, high risk. A white man named Vernon Prater had been arrested for shoplifting $86 worth of goods from a hardware store. He had a prior conviction for attempted armed robbery and 2 further charges. His COMPAS score was 3 out of 10, low risk. In the 2 years following their assessments, Borden did not reoffend. Prater was convicted of a new offense and sentenced to 8 years in prison. The algorithm had been wrong about both of them, and it had been wrong in the direction that the data, across thousands of cases, showed it was systematically wrong, overestimating the risk of black defendants and underestimating the risk of white ones. Northpoint responded to the ProPublica investigation with a detailed rebuttal. The company argued that its algorithm was fair in a different statistical sense, that when you looked at the calibration of the scores, black and white defendants with the same score had similar rates of actual recidivism. It argued that the disparities ProPublica had identified were a reflection of underlying differences in criminal history data, not a product of algorithmic bias. The statisticians who engaged with the Northpoint rebuttal pointed out that the different definitions of fairness that Northpoint and ProPublica were using were mathematically incompatible, that it was impossible, in a population where different groups had different base rates of recidivism, to satisfy all of them simultaneously. But the choice of which definition of fairness to optimize for was a design decision that Northpoint had made without transparency, within a proprietary system that no one outside the company could examine. Meanwhile, defendants continued to receive scores, judges continued to consider them, and no court had yet established that a defendant had a legal right to know how their score had been calculated. The legal challenge came in Wisconsin. A man named Eric Loomis had been sentenced to 6 years in prison, in part on the basis of a high COMPAS risk score. He argued that the use of a proprietary algorithm in his sentencing violated his constitutional right to due process, that he had been deprived of liberty on the basis of a process he could not examine or challenge. The case reached the Wisconsin Supreme Court in 2016. The court ruled against Loomis. It found that the use of COMPAS did not violate his due process rights. The court added a caveat that judges should not use COMPAS scores as the determinative factor in sentencing decisions, but it did not require disclosure of the algorithm's methodology. Loomis appealed to the United States Supreme Court. The Supreme Court declined to hear the case. The ProPublica investigation had produced something remarkable, a detailed, empirically grounded public demonstration that a tool being used to make decisions about human freedom was producing racially biased outputs. It had generated significant academic debate, significant journalistic coverage, and significant public discussion. It had not, in any direct legal or regulatory sense, changed anything. COMPAS continued to be used in jurisdictions across the United States. The algorithm kept running. The COMPAS controversy sits at the intersection of two problems that are each, individually, enormously difficult, and that becomes something close to intractable when they are combined. The first problem is the racial disparity in American criminal justice. This disparity predates algorithms by decades. It is produced by the accumulated effects of policing practices, prosecutorial decisions, defense resource disparities, judicial discretion, and structural inequalities that reach far beyond the criminal justice system. No algorithm caused it. No algorithm will fix it. And any algorithm trained on historical criminal justice data will, to some degree, encode it, because the data reflects a system that already produces racially disparate outcomes, and a model trained on that data will learn the patterns embedded in it, including the patterns of disparity. The second problem is the nature of automated decision-making. Algorithms are not neutral. They are the product of design choices, choices about what data to include, how to weight it, what outcome to optimize for, and how to define the fairness criteria that the system should satisfy. Those choices are made by human beings, reflecting the values and assumptions and blind spots of the people and institutions that make them. When those choices are hidden behind proprietary protection, they cannot be examined, challenged, or corrected by the people most affected by them. The combination of these two problems produces something more dangerous than either problem alone, because the algorithm does not look like bias. It looks like mathematics. It looks like objectivity. And that appearance of neutrality, the laundering of human judgment through the authority of computation, makes the underlying disparity harder to see, harder to challenge, and harder to correct than it would be if a human judge were simply making the same decision on the same basis. Eric Loomis served his 6 years. Brescia Borden, the 18-year-old rated high risk for riding a stolen bicycle, was sentenced to 3 years of probation. She did not reoffend. Vernon Prater, rated low risk despite his prior conviction for attempted armed robbery, reoffended within 2 years and was sentenced to 8 years in prison. The algorithm that rated them had a validation study showing it predicted recidivism better than chance. The algorithm that rated them had produced, across thousands of cases, systematically different predictions for black and white defendants that were not explained by their actual subsequent behavior. Both of these things were true at the same time. This is the thing about algorithmic systems that the language of fairness and objectivity tends to obscure, that a system can be statistically valid and systematically unjust simultaneously, that the question of whether a tool works is different from the question of whether a tool is fair, and that the answer to the second question depends entirely on who gets to define fairness, and whether the people most affected by the definition have any say in making it. In Broward County, Florida, the algorithm is still running. In courtrooms across the United States, risk scores are still being placed in front of judges. Defendants are still being told that a number between 1 and 10, produced by a process they have no right to examine, reflects something true about their future. Some of them are right, some of them are wrong, and the people most likely to be wrong about are the ones who were least able to challenge the score in the first place.